Something about this case feels familiar to the court before a single word is exchanged. This isn't a first encounter, and the judge already understands the pattern forming here. What follows isn't about theatrics or shock. It's about control, patience, and how a courtroom responds when legal arguments begin to drift far outside its boundaries.
All right, Mr. Sigsbee, you're up. 25T01947FY, people of the state of Michigan versus Robert Wayne Sigsbee. And Attorney Bagrakis, would you like to place your appearance on the record?
Tim Bagrakis on behalf of the people.
And Mr. Sigsbee, can you state your name, please?
My name is Robert Sigsbee.
Okay. All right. We are here today on this matter. We're back on an adjourned PCC. We've had a couple of PCCs at this point. The reason for the adjournment today was to ensure we were going to check on the exchanging of discovery. We were here on August 14th, and Mr. Sigsbee has stated that he still needed some discovery. He wanted body cameras of all police officers present at the time of his arrest. And I did order any available body cameras to be turned over to Mr. Sigsbee. So we have a probable cause conference on September 11th as well, because I wanted to give Mr. Sigsbee an opportunity to, file any valid motions that he may want to file prior to exam after receiving all of his discovery. But we set today to make sure.
At this stage, the court is focused on process, not guilt, not innocence. Discovery issues may sound procedural, but they're foundational. If they aren't resolved cleanly here, everything that follows becomes vulnerable to delay or challenge.
That there were any issues in regards to discovery. So, having said that, Attorney Bagrakis, what information do you have for me?
Well, I know my recollection was that initially all the body cam videos were sent to Mr. Hilliker, and I believe he provided them. He indicated that he had provided them to Mr. Sigsbee via a thumb drive. My recollection was also I see we have some cruiser cams, which I had directed my paralegal to send to Mr. Sigsbee because, of course, as the court remembers, Mr. Hilliker was removed from representation. So now we have to deal with directly to Mr. Sigsbee. And there are, to my knowledge, I don't see nor have any other body cams that are available. We've given or will be able to provide him what we already have.
Well, part of the issue, Attorney Bagrakis, was that why I set today's hearing was last time we were here, I believe Attorney Young was here for the process.
Notice the judge's tone here, measured, but increasingly precise. This is the court trying to eliminate ambiguity. Once discovery becomes disputed, judges often tighten instructions to prevent future claims of confusion or unfairness.
Prosecutor's office. And there was some, I don't know what I would call it, back and forth maybe about how discovery was going to be exchanged and where Mr. Sigsbee could pick that up. And so I wanted to make sure that any outstanding discovery was handed to him today in court so that we wouldn't have any questions about where discovery is, whether or not it was exchanged. So
okay. Now that I am looking at Mr. Young's notes to that effect, and obviously not being in court, we can't provide it to him via hand delivery. So
well, and this is the problem we run into when I don't have an assigned prosecutor. that information probably wasn't relayed to you for today.
Well, with all due respect, we've tried to provide as best coverage as we can given the circumstances, but
so what's your plan to get that to Mr. Sigsbee, I guess? That's
what do you want? I mean, are you asking us or ordering us to give it to him directly?
That was my order last time in court. I ordered it last time in court. Yes.
Okay, but obviously, if it was today's date to give it to him in court, we all knew that we weren't going to be in court today, even if I had it in my hands. Right?
Well, so no, actually, no, though. Wait, because last time Attorney Young was here in person, we were all in person. And so we had this kind of long conversation about how a discovery was going to be exchanged. And I said, you know what? I'm going to order any outstanding discovery.
Notice the judge's tone here, measured, but increasingly precise. This is the court trying to eliminate ambiguity. Once discovery becomes disputed, judges often tighten instructions to prevent future claims of confusion or unfairness.
Be provided to Mr. Sigsbee, and I'm going to order that it be handed to him in court on August 28th, 2025 at 11 o'clock a.m. That was my order, and I did that in the hopes that it would ease the process a bit, but it hasn't. So hold on just a second, Attorney McGrath, because Mr. Sigsbee, what did you want to say?
I understand what the court said, but then you were requiring us to come out to court to hand over some this discovery. Yes. All right. Well,
that was my order. I mean, that's what I'm saying. That was my order.
That's fine.
Hold on just a second. Hold on. I need to let Mr. Sigsbee speak. So hold on just a second. Mr. Sigsbee, go ahead.
Yeah, it's critical, because of the angle. The police officer, I watched him pull the sack out of my pocket, my personal Native American herb, and then he shoved it back in and took me to jail with it. I watched this. My friend watched it. He got video of it. I'd like to see the other 10 cops that came there with their guns.
This moment matters more than it appears. When a judge reiterates a past order in detail, it's not repetition, it's record building. If compliance fails again, the responsibility becomes unmistakably clear.
Guns out.
But the issue is just getting that.
I can meet you. I want to confer with the prosecutor. I got a right to do that. So I was wanting to meet.
I'm not. There's nothing really to confer about, sir. I would recommend against. I would recommend against that, and I will. Judge, I will do what I can if the court will indulge us another adjournment. I will make sure that I at least look into the other, making sure that we have whatever copies of either cruiser cam or body cam we have available, that we will get it copied. And if the court tells me to show up at a certain place and time, I will be there, or I will have a representative there to hand deliver it to Mr. Sigsbee.
So, Mr. Sigsbee, if the remaining videos were put on a flash drive, you can use that?
I can use that.
Okay. So here's what I'm going to order today. And I made an order last time and it wasn't followed, but Attorney McGrath, I know that you, hold on, I know that you will ensure that my order is followed. And I know sometimes it's hard for the younger attorneys, the newer attorneys to relay that information for whatever reason, but it was an order that I made. I thought I was very clear about it. But I know that if I tell you, I know that it will get done. So I'm glad that you're here today. So what I'm going to order today is that the prosecutor's office is to put any outstanding discovery on a flash drive and have that available for Mr. Sigsbee to pick up. At where would he go if he were to come to the prosecutor's office to pick that up? Where would he go?
Well, he could come to our office and make contact down here at district court and make contact with my people, and they will let me know that he is here, and we'll make sure that it gets delivered to him, unless you want him to appear in court sometime and we're down there. And
what I'm going to say is I'm gonna pick a day and a time that he can be there, and that way someone from the prosecutor's office can just walk out with flash drive and hand it to him, and that's that. I don't want to have to set another PCC. We already have this September 11th.
Here, the defendant shifts from procedure to narrative. Courts allow this, to a point. But storytelling without legal relevance rarely changes outcomes. It mostly tests the court's patience and focus.
So, what I'm going to say is that, let's see, Mr. Sigsbee, if we said Wednesday the 3rd at some time, will you be able to be at district court to pick that up?
I do believe at this time I can.
Okay.
Judge, can you, again, I apologize. With the holiday and everything, can we do it the following week or later in the week? I mean,
we can do later that week. So we'll do Friday the 5th. Okay, so Friday the 5th, are you available on that day, Mr. Sigsbee?
I will.
All right. So Friday, September 5th, 2025 at, Mr. Sigsbee, you give me a time.
No, I like 11.
11? At 11 o'clock a.m., Mr. Sigsbee will be at the district court at the prosecutor's office to pick up the flash drive, which will have any outstanding discovery on it. It sounded like maybe there are a couple of dash cams. We already had this conversation as well. I know, Mr. Sigsbee, you say that there are, I'm not saying I disbelieve you, I'm just saying what you say is that there should be multiple body cams. Prosecutor's office has what they have.
This is the court regaining control. Specific dates, times, and locations remove excuses. From this moment forward, discovery is no longer a discussion. It's an obligation.
If you believe they have insufficient evidence, then that's something that you bring up at trial. But we're going to go ahead with the preliminary exam with what they say they have. And you can address that you think that there's some things missing or not, but we're not going to be able to not move forward because of that issue, okay? So go ahead. What did you want to say?
It's kind of crunchy amount of time to watch the videos. I mean, I'm going to do it.
Yeah.
So there was like 3 jurisdictions there, plus the sergeant was there. So he was close. You would think the sergeant of the sheriff's department would have his body camera on. And then there was at least 2 Burton cars. I do believe there was around 4 Burton police there. And I mean, if they're running out here, it looked like I robbed a bank is what it looked like. And there's that many people with their police, with their guns. And I couldn't understand this over a traffic stop, a civil infraction. That seatbelt is not an arrestable offense. He had no reason to ask me my ID. So Colder versus Lawson says I don't have to produce an ID.
All right, we're not getting into those things, but I do want you to relay that information of the people that you thought were there, so that Attorney McGregor.
Yes, and the Flint Township was there also.
Okay. All right.
So one of these people should have the angle of the police taking it out and putting it back in my pocket. That's suspicious of a crime in my mind for any cop to lay you out like that. It's that big of a bag. How could you not find it in a pat down?
Okay, and so last thing is the probable cause conference that we set to actually move the case forward was for September 11th, 2025, 11 o'clock a.m. We can leave it on that date, or we can put it a week after that on the 18th if you think you'll need more time, Mr. Sigsbee. It does not.
Time is precious. I'd like to have more time. It would be nice for me.
All right. Okay. Attorney McGregor, are you opposed to putting the next PCC on September 18th?
I am not opposed to that.
Okay. All right, good. Okay, so then we will...
Judge, may I inquire just one thing? Did Mr. Hilliker, did Mr. Sigsbee receive from Mr. Hilliker the discovery that we already sent to him?
Yes. right?
Yes.
Yes.
And there was a flaw in it. And I remember
Well, I don't know. I'm not getting into a discussion about what there is or isn't. What I want to know is, did you receive it from Mr. Hilliker so
Yes,
we don't
I
have
did.
to duplicate efforts?
You're right. We don't need to duplicate the arresting officer's body cam because
Okay.
it's worthless the way he leaned on me that day.
Okay.
Well-
We don't need that right now, but you do have, I remember we talked about that. You do have that discovery.
Yes, I do. For all
Okay.
parties.
Okay, so one more time. This is what my notes state. This is what we're doing. We're going to put any outstanding discovery on a flash drive, and that will be available for pickup by Mr. Sigsby at District Court on September 5th, Friday, September 5th, 2025 at 11 o'clock a.m. That is an order of the court that needs to be done. Probable cause conference will be moved to, and I will find good cause for that because of these discovery issues. Probable cause conference will be moved to September 18th, 2025, 11 o'clock a.m.
Okay.
All right. Thank you.
I never.
All right, thank you. All right, and then that's all of our PCCs today. I believe, Attorney Bagrakis, do you agree?
Yes, I believe we've taken care of all of them, Judge.
All right, very good. Then have a good day.
Have a great weekend.
Yes, you too.
All right.
Yes.
Bye-bye.
We can write you out a notice if you want one.
Yeah, some on paper because I got enough things going on in my own life. You know how that goes.
I understand. All right, very good. We'll see you on the
Get
18th.
this from her right now.
Get it from clerk's office. So.
Clerk's office.
Yep.
In a few minutes. Thank you.
The judge draws a crucial line here. Potential evidentiary gaps don't freeze a case indefinitely. They're addressed later, through motions, cross-examination, or trial, not by halting progress entirely.
Showing that I did give you that flash drive. It showed you all the discovery.
There was one in the digital form.
Yes. Yeah. This came from Tim. It's whatever you had requested that.
Deputy Mays. Deputy Gaza. Gaza.
Right, you can.
And I watched him in the hallway. And I looked at him.
Jerry Rothstein is here.
Okay. So yeah, that should be everything. That you should have everything that we have at this point now. Okay.
It doesn't,
Not-
Okay, you guys ready to go on record?
Yes, Your Honor.
Okay. I apologize. I feel like I might sneeze again, so.
You're fine.
Okay. 25T01947 FY, people of the state of Michigan versus Robert Wayne Sigsby. Counsel, if you can place your appearance on the record, please.
Good morning, Your Honor. Kent Wallace on behalf of.
And Mr. Sigsby, can you state your name?
Robert Sigsby, Executor, Beneficiary Trust.
All right, thank you. Okay, we are here today on a PCC. I know that there have been some discovery going back and forth. Last time, actually, we were scheduled for an exam and one of the police witnesses had an injury and couldn't be in court. That's what my notes state, and so we set it for a probable cause conference for today. We're back today. I am hoping that both parties are going to tell me that we're ready to set this for exam again and that there are no further issues.
Yeah. So Your Honor, to start, regarding the discovery, I have just provided Mr. Sigsby with a flash drive that should have all of the requested discovery on it. There is a proof of service given to Mr. Sigsby, and I asked if I could approach to give one to the court for the case file.
All right, thank you.
Thank you, Your Honor. As for an exam, I have been able to talk to Sergeant Lenowitz regarding the officer. He is able to attend court now, so we are ready for an exam date, Your Honor.
All right.
And we would just ask that at the end of December. That's the only, he needed like another week or something before he was able to walk, so we would just ask that it be set for a December date.
Mr. Sigsby?
Well, I'm gonna need more time, because I'm gonna need time for this FOIA. To the Treasury of the United States, I request you for your W-9 and the court's EIN number, according to 26 U.S.C. 6903. And I think I feel I need to submit to the IRS a 3949A form on what's happening here. So I'm gonna need to see a copy of your W-9. Can you say that on the record, please?
I will, but I'm waiting for you to finish.
Thank you. That is elegant. Thank you kindly. And, I'm looking for a dismissal for this frivolous cause under 12B of the Federal Rules of Civil Procedures. All of them, all 7, are being violated right here on its face. So I'm gonna need to request your W-9 and the court's EIN number. This is a taxable event. And I need to submit a 3949 to the IRS. I need time to send to a FOIA to the Treasury of the United States under 26 USC 6903 for the record, to be reserved on the record, to correct the record.
Okay, all right, so your request for a W-9 or an EIN for me, that request is denied. That's not.
This transition changes the courtroom dynamic. Discovery is now complete, and procedural patience gives way to readiness. From here on, the court's focus shifts toward moving the case forward, whether the defendant agrees or not.
Necessary nor relevant. No, I don't even know if I have an EIN. I don't think that I
You do.
No, don't interrupt me, please remember.
I apologize.
I don't know, the court might have one because the court actually has employees, but I don't have employees, so I don't have one. But either way, the request is denied. It is not relevant to this case, and it is not necessary. And frankly, it's not anything that you need really in any situation involved in this case. The request for dismissal is also denied. There are no rules being violated here. In fact, the court has been more than lenient with you, Mr. Sigsbee, on your requests and different things that you stated and filed and everything. And so that request for the dismissal is denied. Rules of federal civil procedure don't even apply in this hearing. And so, you know, those rules are irrelevant. I encourage you, though I'm not giving you legal advice in any way, I encourage you to focus on the Michigan court rules that apply to this hearing. Those would probably do you better quote than the federal rules of civil procedure. As far as a FOIA to the federal government, I'm not waiting on a FOIA to the federal government. I don't even know how long that would take, and I do not believe it is relevant because, again, you're talking about tax issues and things like this, and we are on a case that involves a count of assaulting, resisting, or obstructing the police, bringing contraband into a prison, and driving while license suspended. And so I am going to give you time, as I have in the past, so that you can be prepared, but I'm not going to grant the request to just simply adjourn until you can get the information you just stated, because that information is not relevant to this proceeding. So here is what I am looking at in regards to a date. I want let's see. So, Mr. Sigsbee, if I were to put this in January as opposed to December, would that make you happier?
It is fine with me, even though I am objection under special restricted appearance that there has been substantive due process violations across the Constitution and the laws of the United States on its face, including the Fifth Amendment. My private property was taken without just compensation. The due process of there was never an indictment. This is a probable cause conference, and that's not suffices to satisfy constitutional substantive due processes that have been violated. And in the 11th Amendment, foreign citizens cannot invoke the judicial system of the United States. And once again, I can read off every way that you guys are foreign right here, easy enough. We have so we're looking at under 4J, Federal Rules of Civil Procedures, all courts, jurisdictions, and immunities fall under foreign state 22 USC 92, 12 through 13 foreign relationships. Once an oath is required, it takes an oath of office to be required. 11th Amendment, foreign citizens are not, cannot invoke the judicial powers of the state. And 28 USC 3002-15A, the definition of the United States means a federal corporation. Foreign Sovereign Immunity Act 1976, 1605 through 1608. The government is liable for violating the sovereign people's rights. And again, under Chinley versus Pegularo, anything that the prosecutor says and puts on the record is to be struck. Attorneys cannot give testimony or be a witness in a court case, and I do believe that has happened here too. So we have mass violations of the Constitution, the laws of the United States, and I'm going to need to see your foreign agent registration supplements and your filings with the Attorney General of the United States. I gave you a judicial notice, and nobody, not the clerk, not the judge, not the prosecutor, not the false impersonating prosecutor, has showed me a shred of anything. This is false impersonation of a government actor under 18 U.S.C. 912.
Okay. The other issues that Mr. Sigsbee brought up earlier, he's brought up on a couple different occasions. That's why I didn't really give you a chance to speak, Attorney Wallace. I apologize, but I believe I made rulings on those things before as well. Was there anything you wanted to say in response to what you just said?
No, Your Honor, I think that this has been discussed on the record multiple times. I think every time that we've been on the record in this case, I think the people's position has been made clear on their statements.
All right, thank you. And so I will say one more time, there have been no due process violations in this case that I have seen or that have come to my attention. There is no requirement for an indictment in this case. That's not how this process works in the state of Michigan.
This is a familiar legal crossroads. Arguments rooted in unrelated federal frameworks often sound complex, but complexity doesn't equal relevance. The court's denial here is less about dismissal and more about jurisdictional clarity.
Michigan, we don't do indictments. They do a warrant and complaint that is reviewed by the judge and then signed by a judge, and then it goes to the arraignment phase, and then it goes to the probable cause phase, and then it goes to the exam phase, and then it goes to the trial phase in circuit court if it gets past the preliminary examination. But we do need to have that preliminary examination. We are going to have that preliminary examination in January. When we get to the preliminary examination date, I will, the request for the other documentation is denied as well. Again, completely irrelevant to this case, and I'm not going to entertain those type of requests. And I do want to tell you, Mr. Sigsbee, when we come back for the exam date, I am not going to entertain a restatement of the arguments that were made today. So if you want to make a new argument about new issues, I'll allow you to do that, but we're not going to go over these things again. We're not going to talk about EIN numbers and all this other stuff that you talked about. We're not going to do that, just like we're not going to go over this stuff because I have already addressed.
This explanation isn't for persuasion, it's for finality. The judge is closing doors that have already been tested. By clarifying process on the record, the court limits future attempts to relitigate settled ground.
The other motions that were filed, so we're not rehashing things. We simply do not have the time to do that. We need to get this exam done. So I am looking at, I believe, January.
We have all of it.
Okay, 20th?
Yeah.
I'm on duty for Judge Crawford.
Oh,
In the morning.
forgot about that.
How would everyone feel about January 20th at 1:00 p.m.?
I'm objecting to any kind of court date, obviously.
I'll note your objection.
I know you will.
Are
I
you
know
free
you
on
will.
January 20th at 1:00?
Elegant would work. Yeah, can I get that in writing?
That works for the people.
Okay, so we will set this for preliminary examination, and we will get you a written notice today before you leave, Mr. Sigsbee. January 20th, 2026, if you can believe it, at 1:00 p.m. All right?
Preliminary exam.
Preliminary examination, so make sure to bring documentation witnesses. That's the time when I'm going to hear those things to establish whether or not there is probable cause to believe that a crime exists or a crime has been committed. A crime has been committed by you, Mr. Sigsbee, and has been committed in this venue being Genesee County. And if probable cause is established, then the matter will move on to your actual trial in the circuit court if probable cause is established.
Thank you, Your Honor.
Good? Okay, thank you, everybody. I did. Oh, I understand it. I just want to give it back to you.
This is a procedural boundary being set. Courts tolerate unconventional arguments, but not infinite repetition. From here on, progress takes priority over debate. By the end of this hearing, the outcome is procedural, but decisive. Discovery is complete. Motions are resolved. and the court has made clear that future hearings will focus on evidence, not theory. The judge's approach remains consistent, patient, methodical, and firmly grounded in state law. What happens next won't hinge on rhetoric. It will hinge on proof. If you found this breakdown helpful, like the video, share your thoughts below, and subscribe for more real courtroom analysis.